Please welcome Pradeep Khosla, Chancellor, University of California, San Diego, and Sonya Sanchez, Senior Counsel, Office of the General Counsel, University of California.
Hello. I'll look the other way. You can leave. You know, this session is both ill-timed and perfectly timed. It is ill-timed because following Dr. Hrabowski is not that easy, so it's ill-timed. But great job. So where is he? There he is. It's perfectly timed because it's about Daca, and as I speak with my colleague here, Sonya Sanchez, who's from the Office of the General Counsel at UC, the Supreme Court, I think, has just about finished hearing the arguments, I think. So we don't know what the answer is, but I'm going to hand it over to Sonya Sanchez in a couple of minutes for her to talk about the legality of the case and the legal basis. I want to start by making a few comments about immigration and about Daca. So you can't talk about Daca without first discussing the history of immigration in this country. And typically, I would have said you would all know the history of immigration, but after Freeman's questioning you all and you not knowing most of the answers, I'm just a little bit concerned. So I'm just going to repeat the history of immigration, just to refresh ourselves so that we all understand how this country was created. So immigration in the country has happened in a series of waves. From 1700 to 1775, yes, that long ago, 500,000 Europeans immigrated to the US. They came as farmers, trappers, butchers, blacksmiths, gunsmiths, loggers, and prospectors for gold, silver, minerals, timber, and coal. During westward expansion in the early 1800s, 50,000 immigrants from China and India arrived with skills to build the transcontinental railroad. And from 1836 to 1914, more than 30 million Europeans brought new skills needed to launch and sustain America's industrial expansion. And then from 1914, World War I, and especially after 1945, close of World War II, another massive wave of immigrants fled war-torn Europe and Asia, bringing new skills and knowledge to the US. Immigrants, skilled, unskilled, and semi-skilled, have added value to this country and built this country. Reports tell us that the children of immigrants, the second generation, as adults, are among the strongest economic and fiscal contributors in the US population. They contribute more in taxes than either their parents or the rest of the native-born population. Immigrants and the children born in the US account for about 1 in 4 people currently living in the US. 46% of immigrants are naturalized US citizens, and another 36% are permanent legal residents. The Migration Policy Institute calculates that more than 2 million immigrants and second-generation Americans are enrolled full-time in US colleges, and they represent nearly 20% of all US college students and 24% of community college students. So the question is, why can't we add the recipients of deferred action for childhood arrivals to this total? Brought here as children, there's only one country they have known. The average Daca came at an age of 6 and has lived in this country for more than 20 years. And what makes them not American, except for a piece of paper? They have lived here, gone to school here in public and private schools. Their families have contributed to our economy in rent, transportation, taxes, and the list goes on and on. They are productively engaged students that are going to be the future of our economy, the next Silicon Valley startup, the next way of doing something or building something. Why would we not want them here right now? A study released last Thursday by the Immigration Initiative at Harvard found that Daca has provided long-term economic benefits to more than 700,000 young immigrants who are working and studying in the US without fear of deportation. Daca has also bolstered the nation's workforce and contributed billions of dollars to the economy. And this report comes as the Supreme Court just finished hearing arguments this morning as to the legality of this program. So opponents of this program say that it interferes with the immigration enforcement efforts and violates federal law. Advocates say the program benefits the recipients and the nation's economy in general. The Supreme Court will, of course, get to decide the fate of Daca. There are approximately 700,000 Daca beneficiaries across the country who continue to legally work, study, serve, and live in America, and these include 1,700 UC students. So to tell us more about the case the UC has filed against the administration to protect Daca is Sonya Sanchez, one of the lawyers in our Office of General Counsel. Sonya, please.
Good morning. Can you in the back hear me? If you can, please raise your hand. Okay, good. Well, I just want to thank APLU and all of you for having me today. I also want to thank Chancellor Khosla for sharing that critical perspective and for sharing this incredible platform today so that we can talk about this incredible moment in history where the Supreme Court has just listened to arguments on the Daca matter. So as you all know, the University of California, along with numerous other plaintiffs groups, is fighting for the future of nearly 700,000 young people who came to the United States as children. The key issue before the court is whether the Trump administration acted arbitrarily and unlawfully when it announced in 2017 that it would end the Deferred Action for Childhood Arrival program, otherwise known as Daca, which has enabled undocumented young people who grew up in the US to go to college, work, and live without fear of deportation. The rescission of Daca has been the subject of countless news articles, scholarly discussions, and has been a dividing topic in recent American discourse. My goal today is to offer you what I hope is a more granular view of the Daca program, the Trump administration's rescission of the program, and to highlight some of the key arguments that will be decided by the US Supreme Court. I will also briefly address the various possible ultimate outcomes depending on the court's decision. Before I talk specifically about the legal challenge, I want to first provide some historical context that highlights the unprecedented nature of the Trump administration's decision to end Daca. Deferred action programs like Daca have been created by each presidential administration for the past 60 years. Daca, like these other programs, stems from a determination that its beneficiaries are making valuable contributions to American society and should not be prioritized for deportations. There are an estimated 11 million undocumented immigrants in the US potentially subject to removal. The government must set priorities and decide which groups to remove and which to allow to remain. As the INS has itself said, application of the literal letter of the law would be unconscionable and would serve no useful purpose. Accordingly, the Department of Homeland Security and its predecessor agencies have frequently exercised discretion not to remove certain categories of undocumented people. In fact, as I mentioned, every presidential administration since 1965 has exercised this programmatic discretion by identifying certain categories of immigrants as low priority for removal. For decades, the legality of deferred action program was commonly accepted. None were challenged in court, and Congress recognized and incorporated several of these programs into amendments to the Immigration and Nationality Act. Virtually all of these programs, and many others, were codified in statutes or regulations, or were designed from the outset to address a temporary disruption. The Trump administration's rescission of Daca is the first time that the government has terminated a deferred action program and subjected long-term US residents to deportation. To provide some additional detail on the establishment of the Daca program, this is important because it goes to the heart of some of the arguments that were made today and will be decided by the US Supreme Court. In 2012, the US then Secretary of Homeland Security, Janet Napolitano, who is UC's current president, issued a memorandum establishing Daca. Applicants were eligible for Daca if, among other things, they came to the US under the age of 6, had resided in the US for a certain period of time, met certain educational attainment requirements, or were honorably discharged from the military, and did not have any significant criminal record and were deemed not to be national or public safety threats. Immigration officials retain discretion to evaluate each application on an individual basis. Applicants provided the government with sensitive information and underwent rigorous background checks. The government launched an extensive outreach program emphasizing that information provided to the government would not be used for immigration enforcement proceedings. Since 2017, nearly 700,000 young people have received deferred action under Daca. Importantly, like all beneficiaries of deferred status, recipients are able to obtain employment authorization and social security numbers, allowing them to work lawfully, better support their families, pursue an education and careers. And as Chancellor Khosla detailed in his earlier remarks, DACA recipients have made the most out of these opportunities and have in turn contributed significantly to U.S. society. Now, turning to the administration's decision to rescind DACA, between 2012 and 2017, the DACA program hummed along. Even after Trump was elected into office, then Secretary of Homeland Security John Kelly specifically exempted DACA from the administration's broader repeal of immigration directives. Trump himself emphasized that, quote, dreamers should rest easy, and said, quote, the policy of his administration was to allow dreamers to stay. Then, in June 2017, the narrative began to change. Then Attorney General Sessions started communicating with several state AGs who had previously challenged a separate deferred action program known as DAPA, D-A-P-A, Deferred Action for Parents of Americans and Legal Permanent Residents in the courts. These communications culminated in a letter sent by 9 state attorney generals to the Trump administration, threatening to file a lawsuit against the administration unless the administration rescinded the DACA program. On September 4th, 2017, AG Sessions, in response to this letter, issued a very short, brief letter to the Department of Homeland Security, simply asserting that DACA was an unconstitutional exercise of authority under the Obama administration. He charged that DACA suffered the same legal defects as DAPA, and just as a sort of note here, DAPA had been enjoined by the Fifth Circuit just prior to this letter. The AG's letter does not elaborate on the purported defects of DACA, and no court has ever found any deferred action policy unconstitutional. So the next day, the acting Department of Homeland Security Secretary Elaine Duke issued a memorandum summarizing the history of DACA and DAPA, briefly describes the DAPA litigation, and it made reference to Attorney General's half-page letter. The memo then provides just a very brief one-sentence purported rationale for why the administration was ending the DACA program. Critically, in rescinding the program, the Trump administration did not consider any of the benefits of DACA or the personal, professional, or economic costs of rescinding the program. To name just a few of these costs, DACA recipients would have been subject to removal from the US, would face a 10-year re-entry bar. When their work authorizations expired, they would no longer be eligible for employment, losing their livelihoods and their employee-sponsored health care. And I just want to put a human face on this point and highlight the story of one of our UC declarants in the lawsuit. His name is Mitchell Santos Toledo. He arrived in the US from Mexico at age 2. After high school, Mitchell was accepted to UC Berkeley, but could not go because his family did not have the financial means. Several years later, Mitchell received DACA status. This allowed him to enroll at UC Berkeley and support himself by working several jobs. He was also able to obtain health insurance, a driver's license, and travel on an airplane for the first time. He graduated from UC Berkeley and was his program commencement speaker with highest distinction, and is currently enrolled at Harvard Law School. The rescission was announced days after Mitchell had taken out large loans to pay for law school. In addition to the individual costs of the rescission of DACA, I also want to talk about the consequences for employers and schools and universities. Employers of DACA recipients like UC would lose skilled workers, face the loss of research expertise, exchange of ideas, and cultural vitality that is central to our academic mission. UC would lose its investment in time, financial aid, and research funds, housing benefits, and other support for DACA students who could no longer work and continue their education. None of those downsides are theoretical. In fact, some DACA students did in fact cancel their enrollment following the rescission announcement because of fear that they would not be able to repay their loans when the program was ended. Knowing what the rescission meant for 1,700 UC DACA students, their families, and the UC of California community in general, the university was among the first parties to file a lawsuit asking the court to set aside the Trump administration's rescission of DACA on grounds that the decision was arbitrary and capricious. The lawsuit charged that the administration failed to follow the Administrative Procedures Act, which sets forth procedures that are required before ending a program of DACA's magnitude. UC filed its lawsuit shortly after the rescission was announced. During that time period, we developed a robust factual record using statements from DACA students, various university administrators, including President Napolitano, faculty from across the system, including our health system, and others who could speak to the tremendous contributions of our DACA students and the broader DACA community. In order to convince the court to immediately prohibit the Trump administration from rescinding DACA, our factual record had to establish that the rescission would cause irreparable harm to the DACA recipients, as well as to the university and other institutional plaintiffs, and that we, the plaintiffs, were likely to succeed on our Administrative Procedures Act claim. In January of 2018, a federal judge in the Northern District of California ruled in favor of UC and ordered a nationwide preliminary injunction, which is a temporary restraining order that remains in place for the duration of the lawsuit. This order halted the termination of DACA. The order restored the DACA program to the state it was in before the rescission, except that the government does not have to accept new initial DACA applications, nor does it have to process DACA recipients' requests to travel abroad. The Trump administration appealed the lower court decision on November 8th, and on November 8th, the Ninth Circuit issued a decision in favor of UC and the other plaintiffs, affirming the lawfulness of the preliminary injunction. Several other courts of appeal across the country have issued similar decisions. These cases have been consolidated and were presented to the Supreme Court this morning. Now, I'm just going to very briefly touch upon the two legal arguments that are before the Supreme Court. The first one of these arguments is very procedural, so I won't spend much time on it. And the second is one that I've already mentioned throughout this discussion. So the first issue is whether the government's decision to rescind DACA is immune from judicial review. The government argues that this highly consequential decision is not subject to court review because the decision was, quote, committed to agency discretion. But the courts recognize a strong presumption in favor of reviewability, particularly in cases like this one, where you have a general applicable policy that affects hundreds of thousands of people. Decisions to terminate such policies have traditionally been deemed reviewable by the court, so we remain cautiously optimistic that we will prevail on this first question. Assuming we do prevail, the second issue that the court is considered today is whether the administration's decision to rescind the DACA policy was arbitrary and capricious. Under the Administrative Procedures Act, there are processes the government must follow when rolling back administrative policies already in place, and there is a heightened standard of reasoning that the government needs to meet before ending a program on which so many people rely. The agency, before rescinding a program like this, must examine the relevant data and articulate a satisfactory explanation for its actions. The Trump administration, we argue, failed to meet that standard, offering only vague and conclusory explanations that were at odds with Trump's assertion that his administration would allow DACA recipients to stay and that, quote, dreamers could rest easy. Acting Secretary Duke's one-sentence explanation that I mentioned previously, we argue, cannot withstand judicial review. The Duke memorandum does not explain the basis for concluding that the DAPA litigation compels the conclusion that DACA is unlawful, nor does it address the differences between those two policies. Then those differences are indeed significant. DHS also failed to demonstrate that it gave adequate consideration to the welfare of the individuals affected by the decision or the reliance of DACA participants on the policy. Now, one final word about the Supreme Court case. More than 1,000 individuals, companies, institutions of higher education, religious institutions, law enforcement officials, advocacy groups, and scholars representing nearly every element of American civil society have signed on in support of this legal challenge. There's really been an absolute tremendous showing of support for our position in this case. And if I'd been able to lug the briefs with me, you would see a stack of green legal briefs about this high submitted by all of these various supporters. So what can we expect next? So a decision is expected by June. It may come earlier, but we certainly expect a decision by June. If the Supreme Court rules in UC's favor, the decision would not necessarily restrict the Trump administration from making another attempt to rescind Daca. It would simply mean that officials would need to follow the proper procedures and provide a clearer rationale for ending the program. And any such future attempt to rescind the program could again be subject to judicial scrutiny. If the Supreme Court sides with the Trump administration, that would likely mean that the administration would be free to proceed with the rescission of Daca, though the timeline could depend on the court's decision and how the Department of Homeland Security was to implement the rescission. So we face a tremendous amount of uncertainty, and that uncertainty will remain until the Supreme Court rules. In my most recent conversations with our Daca community, the anxiety and fear has never been more real. UC, and I'm sure many of your institutions, will continue to provide a safe and supportive environment for our Daca students, and in UC's case, continue to advocate for Congress to make these protections permanent. Thank you again for having me.
Thank you, Sonya. So we have time for a few questions, and then I'd wrap up by giving you some homework before you leave. So any questions on the issue? I think this is the most comprehensive explanation I've heard in terms of the basis of the lawsuit and why it made sense in the first place to file the lawsuit beyond just humanitarian issues. There are also legal issues on which it was filed. So nothing?
I think there's one.
Yeah, please.
I want to start by thanking you for that comprehensive overview. When we hear a lot of the rhetoric around these decisions, it's wonderful to hear what's really happening. I do wonder about the way in which the argument is being framed in support of Daca. It seems as though it's really inviting the administration or future administrations to come up with what they would see as a more compelling argument against Daca. So I'm sure this has all been taken into consideration, but it feels like it may be pushing this issue down the line to reemerge, and I'm just wondering what your thoughts are about that.
Sure, yes. I guess what I would say is that litigation is not going to lead to comprehensive reform and to permanent reform, and there's simply not a legal basis that can provide the remedy that I think most of us or all of us in this room would hope to see. What we were able to do within the sort of four corners of the law here was to file this preliminary injunction to stop the immediate effects of the Daca rescission, which was it's been quite significant. It has allowed all of our Daca recipients to renew their Daca status, so they really were able to put additional time on the clock. Had we not received this preliminary injunction, we would have seen hundreds of thousands of students and undergrads having to leave their studies on a rolling basis. It is possible that the Trump administration, if we prevail, we won't really know what the contours of that look like until we see the US Supreme Court's decision. At that point, I would expect the decision to go back down to the district court, and we may have some more instruction there. But I think, if we were to prevail, it would be reasonable to assume that our Daca students could renew yet again for an additional 2-year period. But I do agree with you. At base, we need a permanent fix. That fix must come from Congress. It is not going to come from the courts.
Now, there's an opportunity coming up in November. Just saying. Yes, sir.
I'm just going to say, Peter McPherson here, this is why this need for permanency to put this in place almost regardless of the court case.
Right.
If we lose, obviously, but if we win, we still need it permanent. So it'll be a very high priority for APLU, and I think all of you, to work to get this legislation by. Extremely difficult in this polarized time, but certainly I think we all have a commitment to do exactly that.
Thank you.
So, Peter, I have to say that even when I came on a visa, the fact that I was on a temporary visa and didn't have a green card, and there was always uncertainty about would it be renewed, will I get a green card, what would it take, really wears on you as an immigrant, even when you're doing everything by the book. So I think I can only imagine if you're a Daca beneficiary, it is 10 times or 100 times worse. Because the uncertainty is much greater than even when you have a legitimate visa and you enter the country, which is where I was. So,
well, it's very clear. I know we're about running out of time, but it's very clear that we need comprehensive immigration reform.
Right.
We need to have more immigrants in this country. We need to have visas stamped to our diplomas, if you will. I know we've talked about this, but these are all key issues, and I think the higher education community, including APLU, will continue to be very aggressive in this matter.
can I add a couple of homework items? In the meantime, I think we can do something while we're waiting for the Supreme Court. So, for example, when you go back, you should look at your local state and laws and see if you can help Daca students. I know some states allow Daca students to be counted as in-state, whereas others absolutely refuse that. And I think that by itself can make a really big difference. Put together a working group and review your institution's policies and what you could be doing. I know in the UC system, for example, we have decided to fundraise on the outside, private donors to create scholarship and other opportunities, forms of financial help for Daca students. And maybe you have a donor in your institution. Maybe your leadership would allow you to do that. Again, expand programs that help Daca students. Again, you got to do this legally. Partner with local NGOs. There are local NGOs that really want to be partaking in this opportunity and making sure that the Daca beneficiaries continue to be not living in angst all the time. So there are a lot of things one can do, not clear which will help and which will, where you will succeed, but unless you try multiple of these strategies, you will not know which is the one that is good for your institution and your locality, right? And anything that you can do to convince your leadership, your president, your chancellor that they should be supportive, you should be doing. If you want us to write a letter, happy to do that. But I think we really need to support these young men and women who are here trying to do a good job, contributing to this economy, and they really belong here in our institutions in the country. So,
can I just add two quick points to that? So, thank you for commenting on the anxiety and fear. We are seeing a sharp increase in mental health needs of this population, given the current stress that they're under. So another sort of homework item to consider is ensuring that there's culturally competent and accessible mental health support and other types of support for your Daca students. And kind of a related point is, to the extent that you can connect these students with legal resources now, this is really critical. Some of your students may actually now have a path to legalization that they did not otherwise have at the time that they applied to Daca. So if they can get a comprehensive immigration intake and really understand what their options are before the Supreme Court decision comes out, that's a good use of resources.
So I think we need to stop here. So thank you very much. And anything we can do to help APLU, please call. So thank you very much.